Okay, this video is actually going to focus on how the Supreme Court actually hears a case. Like, what actually happens when the rarest of the rare case actually reaches the Supreme Court. Like, how does that case actually happen? It's very different from what you would see like in your favorite crime drama on TV, where like the courtroom action is sort of like fast and furious, like people objecting and I sustain all that kind of stuff, right? Witnesses, like that doesn't really happen on the Supreme Court level. Couple things. Number one, the Supreme Court hearings are not televised, and cameras are not allowed in the courtroom. So that's something to consider. You can't have cameras in the courtroom. So we have audio recordings, but there are no cameras, and there's arguments on pros and cons on if that should be allowed, but we don't. Like there are no cameras in the courtroom. And you could argue that like maybe even having cameras in the courtroom wouldn't be all that interesting because again, it doesn't run like a typical court case. Most of the arguments happen before the actual hearing. Both sides of the argument submit what are called briefs, which are sort of like written arguments that really sort of like support their side in the dispute. They're really misnamed because these are super long and they're pretty tedious and very like legally based, and it's a lot for the justices to read, which is one of the major reasons why the Supreme Court only hears so many cases in a year, which is not many, because of like how much reading this requires them to do. So each side would bring forth a an argument. So the two people involved in a Supreme Court case are the petitioner and the respondent. The petitioner is the individual or the group that lost in the lower court and is fighting to have the Supreme Court overturn the previous court's ruling. The respondent is the group that won the lower court ruling, and they just want the Supreme Court to sort of like uphold the decision that the lower court made. So each of those groups will submit written arguments that argue on their behalf. Outside interest groups also can submit briefs. So these are called amicus curiae briefs, which stand for it's like Latin for friend of the court. And like if you're not directly involved in the case, but like the Supreme Court sort of like decision may impact you or your organization, you have the opportunity to also submit sort of like how you think the Supreme Court should rule. So it's not just the petitioner and the respondent submitting arguments, it's all these other groups that may be impacted by whatever the case is about. So it's a ton of reading that has to be done by the justices. And one of the things that they'll spend time arguing about in these written arguments are like previous decisions made by the court, which we call precedent, and how that would favor their side. Like you ruled this way in that case, so you have to rule in favor of us because it's a similar type of case. So they'll dig back through all of the previous Supreme Court rulings and try to find cases the Supreme Court has already ruled on that they feel like favor their side. These are submitted months ahead of time. The justices will pick apart their legal arguments and sort of like be ready to go on the actual hearing day. When each side actually gets their day in the Supreme Court, believe it or not, they only get 30 minutes apiece to make their arguments in front of the justices. So each side gets 30 minutes. It's a pretty strict time limit. And this time limit can be interrupted by the judges at any point. So you only have 30 minutes, and you have all these things you want to tell the justices about why they should favor your side. But at any point, they can sort of jump in and ask you questions, whether about your brief or things that you're saying, and sort of question you about the arguments that you're making. It's also important to note that one of the positions in the United States government, the Solicitor General, is responsible for arguing all cases in which the United States government is a party in a case involved with the Supreme Court. So Elena Kagan, who's one of our current Supreme Court justices, though she never had any judge experience previous to becoming a Supreme Court justice, she was the U.S. Solicitor General that argued the cases involving the United States government in front of the Supreme Court. So she knew how the process worked, and the other Supreme Court justices were familiar with her because of that. And if you look, just as an example, the case we've already talked about, Citizens United versus FEC. So, there was a petitioner, Citizens United, and there was FEC. By the way, the petitioner is always listed first in the suit. So whatever side you always see in the Supreme Court case listed first, They were the ones that were fighting to have the lower court ruling overturned. The second one is always the respondent, which is the group that essentially is looking to have the previous court ruling upheld. And then you'll also see that like all of the other groups that submitted essentially briefs of the Justice of Reed, which is a lot. And then deciding the case, this may be months after the oral arguments are actually heard. It just takes 5 justices to rule in favor of a side to have the case won for that individual. It does not have to be unanimous. Basically, after the justices reach a decision, one individual, one of the judges on the majority side, will be selected to write what's called the majority opinion, which will explain why that individual ruled the way that they did. One of the justices from the losing side, the side that like was outnumbered, will be chosen to essentially write the dissenting opinion. Right? So that's you're gonna have sort of like both explanations, why the majority won, and then why the people disagreed with the majority verdict. And then basically, you also have the opportunity to submit what are called concurring opinions. Because you only have one person on each side that is writing sort of like the opinion on the majority winner and then why the majority got it wrong, you as a justice, if you're not going to write the majority dissenting opinion, could choose to just attach your explanation, which would be a concurring opinion, right? So that's possible too. So you're always going to at least have a majority opinion. A lot of the cases have gone 5-4 or now 6-3 because that's the ideology sort of split on the court. But it's also possible to have like a 9-0 verdict. It could be unanimous. And then you would just need a majority opinion. You could have concurring opinions, but clearly there's no dissenting opinion if it's unanimous.